Hillary, this is Ann Thompson. Can you hear me?
Hear you, but I will tell you that we are on YouTube live. So
okay, I just wanted to make sure you could hear. Wasn't hearing anything being said.
Oh, I just now heard you when you unmuted, but I wasn't hearing you before that. No.
Okay, thank you. Your Honor, this is Ann Thompson. I don't know if you can hear me or not, but I can't hear you at all. I cannot hear you, sir.
How about now?
Yes, sir, I can hear you fine.
Sorry, I didn't toggle back over from my external microphone that we had in court today. So if I don't switch back over, it's not picking me up, I guess, because it's turned off. So, okay, I'm sorry. All right, Mr. Stevens, are you ready on Mr. Rodriguez on your writ in WR 240 seeking bail reduction?
Yes, sir, I'm ready.
All right, State, are you ready? I see that it was filed on July 1st by Mr. Stevens.
Yes, Judge. I don't believe that we have a copy of the writ, but I have looked into Mr. Rodriguez's jail record and state's ready to proceed.
Mr. Stevens, did you provide a copy to the state?
Your Honor, I really don't know. My wife e-filed it for me, so I don't know if it automatically goes to the state or if we specifically should send it. I don't know, honestly, Judge.
Well, on the e-file system, you would have to select the DA e-files to ensure that they get an electronic notice of it. So
I'll make sure.
Just make sure that the state is noticed on them. Otherwise, if they start asking for continuance for preparation, I'm going to grant that.
I understand, Judge. I don't want to worry. I'll tell my wife we'll get it right next time.
Okay. All right. So are you ready, Ms. Heisel? You said yes?
Yes, Your Honor.
All right. And is Mr. Rodriguez present there? Mr. Rodriguez, and can you see your attorney, Mr. Bill Stevens?
Yes, sir.
Okay. And Mr. Stevens, you can see and hear Mr. Rodriguez?
Yes, sir.
All right. Go ahead, Mr. Stevens.
Your Honor, we brought the writ, of course, and I would like to call my client to testify.
All right, Mr. Rodriguez, if you will, at this time, raise your right hand. I'm going to place you under oath. Mr. Rodriguez, do you swear that the testimony you give today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
Brad Rodriguez.
Brad, about how long you been in jail now?
A month and a couple of days.
Okay. And your bond is currently, I believe, set at $25,000. Is that correct?
Yes, sir.
And obviously you're still in jail, so you and your family have not been able to raise enough money to post that bond. Is that correct?
Yes, sir.
Okay. Now, if we get the bond reduced and if you get out, where would you live?
With my mom.
Okay. And would that be here locally?
Yes, sir.
Okay. And your brother is the alleged victim of this alleged assault. Does he live at that address?
No, sir.
Okay. And you realize that you would not be able to have any contact with him?
Yes, sir.
Right. Okay. Now, do you have any money in any bank accounts in order to post this bond?
I don't, but my mom, she may.
Okay. And I've discussed this with your mom, and I'll tell you about it in just a minute. Okay.
Yes, sir.
Do you own any property that you could sell, pawn, or mortgage?
No, sir.
Okay. So you're going to totally rely on your mom or other family or friends to help post a bond, correct?
Yes, sir.
Okay. Now, I did visit with your mom, and she did tell me that your brother's moved out. And she told me she's gonna try to post the bond for you. However, are you asking the judge to reduce this bond to $5,000?
Yes, sir.
If the judge reduces it to $5,000, is that an amount that you believe that your family might be able to come up with the adequate funds to post bond?
Yes, sir.
Okay. Now, if you get out, Brad, do you have transportation to get to and from the courthouse or the probation department or any other obligations the court puts on you?
Yes, sir.
Okay. Do you have a vehicle, or is maybe providing that for you?
It will be my grandma.
Okay. Is she in a position she could take you to and from whatever you need to have done?
Yes, sir.
Okay. Now, how about employment, Brad? Okay. I think you told me that you do like odd jobs, basically. Is that correct?
Yes, sir. I do landscaping.
You told me that you had some customers lined up for your landscaping jobs. Is that correct?
Yes, sir.
Okay. So if the judge were to reduce the bond to an amount that your family could make, would you be able to go and start earning money to, you know, to help pay your family back for the bond or any other obligations you have?
Yes, sir.
Okay. Are you sure? Will you assure this judge that if he does reduce a bond and you get out, that you'll make each and every court appearance as required?
Yes, sir.
Okay. Are you asking the judge to reduce the bond to $5,000?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
Go ahead, Ms. Heisel.
Thank you, Your Honor. Mr. Rodriguez, are you aware of the charge that you are facing?
Yes, ma'am.
And what is that charge?
Assault.
Okay. If I told you it was ag assault with a deadly weapon, would you think that was accurate?
No, ma'am, because there was, like, my brother, I mean, there was no weapon involved.
Okay. So you've not been notified that you are being held on aggravated assault with a deadly weapon?
They didn't say that.
Okay. In regards to the bond, Mr. Rodriguez, have you talked to any bondsmen about that $25,000 bond that you currently have?
My mom, I think she has.
Okay. Are you aware of how much a bondsman would require your mom or you or yourself to put up to make that $25,000 bond?
No, ma'am.
Okay. I believe Mr. Stevens' testimony was that your mom was attempting to bond you out. Do you believe that your mom would be able to make a $25,000 bond for you?
She should.
Okay, Your Honor, no further questions for this witness.
Ms. Heisel, confirm for me how long Mr. Rodriguez has been incarcerated?
Yes, Your Honor, I show this to be his 29th day in the Van Zandt County Jail.
29th day. All right, Mr. Stevens, would you like argument?
Briefly, Your Honor, yes, sir.
Go
I
ahead.
did speak with Mr. Rodriguez's mom. She has very limited funds. However, there is no way she can make a $25,000 bond. She said if it got reduced to around $5,000, that she has spoken with a couple of bondsmen and thinks that she would be able to borrow some money through family and other friends to get him out. So we're respectfully asking Your Honor to reduce the bond to $5,000. Thank you.
Ms. Heisel.
Yes, Your Honor. Given the amount of time that Rodriguez has been in the Van Zandt County Jail and the charge, I did confirm through the Justice Solutions page that he is charged with aggravated assault with a deadly weapon, a second-degree felony. Due to the nature of the charge and the amount of time that he has been in jail, at this time we feel like a $25,000 bond is reasonable. Mr. Rodriguez, for whatever reason, believes that his mother would be able to post that bond, does intend to post a bond for him. We would ask the court not to reduce the bond at this time, given that the state does not have an offense report. And to my knowledge, the court doesn't have information in front of it. I think based on the charge, the current bond is fair and reasonable, and there's been no substantial evidence otherwise.
Ms. Heisel, are you aware of any criminal history, previous history for Mr. Rodriguez?
Let me. Judge, I know that we do not have the complete case from the arresting agency, but let me look and see if we have his criminal history. We do have it, Judge. Just give me a second to pull it up. It looks like Mr. Rodriguez has a prior conviction for assault, family violence, as well as a terroristic threat of a family member or household, as well as it looks like 3 felony convictions, Your Honor.
3 convictions in addition to terroristic threat and assault?
Yes, the felony, they're non-violent felonies, but they are felony convictions.
And what are they?
There's abandoned and endangering a child, burglary of a habitation, and possession of a controlled substance, PG1 under a gram.
And Mr. Stevens, do you oppose any of that information coming to the court? Do you believe that not to be true?
From talking to my client, Your Honor, I do believe that information is probably accurate.
Okay. All right, then based on the information and evidence before the court's going to find that a $25,000 bail is not excessive. Court will deny the writ of habeas corpus. Court will retain $25,000 bail on Mr. Rodriguez. Court will reconsider that if Mr. Rodriguez is not indicted within the 90 days.
Thank you, Your Honor.
All right, so, and I believe that there's probably conditions of pretrial release on Mr. Rodriguez. I'm not sure if those have been issued to him at the jail, but if not, the court, if Mr. Rodriguez is indicted or placed on bail, then the court will impose conditions of pretrial release at that time.
Yes, sir.
All right. Anything further, Mr. Stevens?
No, Your Honor, that's all I have.
All right, then that will conclude this hearing.
All right. May I be excused, Your Honor?
Yes, yes. Thank you, Mr. Stevens.
Thank you, Judge.
All right, Thompson, are you ready on Mr. Judson Brown and your writ seeking bail reduction?
One issue to bring up before the court, Mr. Brown did file a pro se motion for a different attorney. I don't know if the court would rather address that first or the writ.
Has that motion been provided to the state?
Yes, Your Honor.
All right, have you had time to review that, Ms. Heisel?
Judge, no, I have not. I'm aware that it was sent to our office by Mr. Brown from the jail, but I don't have a copy of it in front of me.
All right, give me a moment, Ms. Thompson, and let me review the clerk's file and see if we have it as well.
Sure.
The only thing contained in the clerk's file at this time is an application for writ of habeas corpus filed June 17th. Proposed order and notice of setting. So I do not, there's been no motion filed with the court.
If you give me a moment, Your Honor, I can tell you when he filed it with the district clerk's office.
Yes, ma'am.
And Judge, absent any of Ms. Thompson's information to the contrary, it appears from our copy that it was faxed to us from the jail, but not filed, unless Ms. Thompson knows something I don't know.
No, Your Honor, that is correct. I've got it in front of me, and that it was just faxed to my office also from the jail. So
Do we
it
have
was not,
anything, do we have anything with a file stamp?
no, sir, I do not.
Well, counsel, it's up to you. If there's nothing before if there's no formal motion filed before the court, don't know that I can really grant much, but I'm willing to listen if that's what you want me to do, Ms. Thompson.
I think at this point, Your Honor, that is beneficial to my client. That's what he wants. At least that's what I've been able to determine. I will just say that was appointed on June the 9th. He called my office on the 12th. We set up a teleconference for where I could spend time to talk to him about his case. Because couldn't on the day of the 12th. I had another court proceeding. I waited for his call on the 16th. I never received any call from him. Then on the 19th, he calls. He's upset. He is telling me that he tried calling me all day and I didn't have an answer machine and I wouldn't answer his calls. I told him that was false and that made him angry. He was very rude. He was cussing. He was screaming on the phone, and basically he hung up. I prepped to mail a letter to him, and then the very next day I received this pro se termination of counsel. On the 26th, after hours, he called my office, and I picked up and I talked to him. And I discussed with him the possibility of enhancements in this case, which was very upsetting to him, understandably. He demanded this case be finished ASAP so that he wanted doing this at the instruction of his Dallas counsel. He wanted the bond hearing, and I tried to explain to him that because he has a parole hold on him, that he could not get released. In addition, he has a Dallas hold on him. He demanded to have it anyways. I attempted to try to tell him how the loss of credit, and he again hung up a second time. I then traveled to Canton on the 30th to meet with him to discuss in depth his case as I knew it at that point, because I have no discovery. He's not been indicted. He was not hearing any of that. He didn't want to hear any of that. He was very argumentative, very disrespectful, and basically stood up and walked out of the meeting. And that's where it's ended, Your Honor.
All right, Mr. Brown, if you will, raise your right hand. I'm going to place you under oath. Mr. Brown, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, would you like to present your motion to me, please?
Yes, sir. I talked to Ms. Thompson over the phone. She was very short because she was in court and told me to call back on Monday. Monday I called back. The phone system, it didn't ring. It didn't do anything like it did the Thursday I called her. Now I called again and called again. It had just a blank system, and then it went to the music that it normally has here. So I tried all that day. And then they moved me to a new cell. And then once they moved me to a new cell, the phone was able to ring and I was able to talk to her over the phone. She did tell me over the phone that it would not benefit the court, that it would be in the court's best interest, and that she doesn't work for me. She works for the court. She said that over the phone, and then she hung up on me. So because I tried calling her back, she did not answer. And I did contact my Dallas attorney. My Dallas attorney told me that he can get a blue warrant lifted, that parole is also lifting blue warrants at this time, that they are placing bonds on them to allow offenders to fight their trial instead of being locked up. So I'm trying to get this set to where I can get to Dallas County and have my no hold in Dallas lifted and my bond lifted for my parole.
Who is your Dallas attorney?
Philip Hayes.
Is he hired or appointed?
He's appointed, but my family is working right now to try to get me a hired attorney.
Do you believe that they're going to be able to do that?
I'm not too for sure just yet. I know I'm waiting on my second round of stimulus to come through since I did file taxes. I'm waiting on that to come in, and then I have my mom. She says she might be able to help, and my stepmom says she might be able to help as also because she does work in a law office.
Well, Mr. Brown, you requested the court to appoint you an attorney, and the court has done that. And I haven't heard from either you or Ms. Thompson any grounds that would allow the court to remove her as counsel. So I'm gonna deny your request for her to be removed as counsel or whatever. I don't even know what your request is because you didn't file it with the court. I'm just going based on what Ms. Thompson and Ms. Heisel told me, but I'm gonna deny any request for appointment of counsel at this time. If you or your family are able to hire an attorney, then once you do that, that attorney should file a motion to substitute, and then we can address this issue again between you and Ms. Thompson. Right now, though, Ms. Thompson is your court-appointed attorney. You understand that? Okay. So, Mr. Brown, do you want Ms. Thompson now to argue the motion for bond reduction?
If she wants to, that's fine.
Ms. Thompson?
Okay. Ms. Brown, did you receive a letter about addressing the credit if we had this bond hearing?
Yes, ma'am.
Okay. Mr. Brown, you understand that if the court chooses to reduce this bond, that you will have to make all appearances in all settings. Do you understand that?
Yes, ma'am.
And do you know that your bond right now currently is $20,000? Is that correct? And $1,500 on a misdemeanor.
Yes, ma'am. If I'm not mistaken, when I was in Dallas County, I did bond out on that $1,500 because it did show up in my Dallas County.
Okay. Are you employed?
No, ma'am.
Okay.
But
Do you have any?
Get out.
Okay. You just try to answer the question, yes or no. Okay. Do you have a vehicle?
Personally, mine, no, ma'am.
Okay. So, but if you were released, would you have the means and the ways to get to court?
Yes, ma'am.
And who would do that for you?
My father. My father would provide me with a vehicle.
Okay. And where would you reside at, Mr. Brown?
And my mother's.
Okay. You have the means, financial means in any way to make this $20,000 bond that you currently have?
No, ma'am.
Okay. And you're asked, if you could get your bond lowered, would you be able to make a bond in the range of $5,000?
Yes, ma'am, possibly.
Okay. And are you asking that court today to consider doing that?
Yes, ma'am.
Pass the witness, Your Honor.
Ms. Heisel, any questions?
Yes, Your Honor. Mr. Brown, are you aware what you have been charged with in Van Zandt County?
Yes, ma'am.
What is that?
It's gonna be a evading arrest with a motor vehicle, evading arrest and detention with a motor vehicle.
Okay. And do you know how many days you've been in the Van Zandt County Jail?
A little over a month now.
Okay. So if I told you 37 days, that would sound accurate to you?
Now, June 2nd would be my day.
Okay. And are you aware that you currently have a parole hold out of the Texas Department of Criminal Justice?
Yes, ma'am. I'm in contact with them.
Okay. And are you aware that you also have a hold out of Dallas County?
Yes, ma'am. I'm
Do you
also
have
in contact with the bonds company there.
Okay. Have you made contact with any bonding companies here in Van Zandt County related to this charge?
I have not. I think my family might have, but I have not personally.
Okay. So you have no personal knowledge about what you would need to put up to make really any kind of bond?
I know that they normally grant it at 10%. I do know that, but other than that, no, ma'am.
Okay. Your Honor, I have no further questions for this witness.
Mr. Brown, have any criminal history other than what's been testified to?
No, Your Honor.
So this is his only charge out of Van Zandt County ever, is evading arrest, the motor vehicle?
No, Your Honor.
I'm sorry. Let me look here. No, Your Honor, actually, the state appears to have the wrong, I don't know if it's the wrong or if it's just incomplete criminal history for Mr. Brown, because his criminal history return is not syncing up with just what I have him on in Van Zandt County for. So I guess the short answer is, Judge, I'm not aware of what his accurate criminal history information is.
Mr. Brown, you have been convicted in Van Zandt County, haven't you?
Yes, sir.
For what?
I signed 8 years TDC for burglary of habitation, second degree, and I signed 10 months state jail on the theft of 1,500 to 20,000.
And that was out of my court, wasn't it?
Yes, sir.
And that's what your parole hold is on?
Yes, sir.
All right, thank you, Mr.
I currently have less than a year on parole, or a little over a year.
All right, thank you, Mr. Brown.
Sir.
All right, the court, having considered the testimony of Mr. Brown, the argument of counsel, court finding that Mr. Brown has been incarcerated for more than 30 days and that Mr. Brown being charged with evading arrest or detention with a motor vehicle, a third-degree felony. Court finds that a $20,000 bond is not oppressive or excessive at this time. So the court denies the request for a bond reduction in this matter. Court will reconsider that, Ms. Thompson, if Mr. Brown is not indicted, obviously within the time prescribed by law.
Yes, sir.
All right, so Mr. Brown, my best advice to you is to continue to work with Ms. Thompson. And if there's any further issues between you and Ms. Thompson, I'm sure that one or the both of you will bring that to my attention. But I would ask that the two of you work as best as you can together. And if there's any issues that we can get past, I recommend that we get past them so we can try to make some positive headway in Mr. Brown's current case.
Sure.
Yes, sir, Your Honor.
All right. If there's nothing further, Ms. Thompson, then we'll be adjourned.
Thank you, sir.
All right. Thank you. You have a good day.
Judge, I have one more matter I'd like to address with the court before we sign off.
Yes.
This morning, Travis Skinner, you granted a nice eye on him. He did not appear for his arraignment this morning. The state has received information that the reason that he was not in court this morning is because Mr. Skinner cut off his ankle monitor he had as a condition of pretrial release on his other indicted charge and attempted to commit suicide. He was not successful. He has been taken into custody for his safety, but we would ask Judge that his bond be quadrupled in that nice eye.
You said that he is currently in custody
I believe so.
here in Van Zandt?
I don't have that information, Judge.
And the ankle monitor was a condition of pretrial release?
Yes.
All right, the court will take that into consideration in the issuance of the alias capias and new bail. All right, thank you, Ms. Heisel. I appreciate that information.
And Judge, if you would just let us know what that amount is so Ms. Abney can execute that nice eye for the court.
Do you know what his current bail was?
I'm getting into it right now, Judge.
Judge, am I needed any longer?
No, ma'am. I believe we're through at the jail unless any of the deputies there indicate that we have any extraditions or anything like that they need assistance on.
I'm alone in the room.
All right. Do you want to check with them to make sure usually they'd let us know, but you want to check with them to see if they need any extraditions or anything like that done?
I will do that. Yes, sir.
All right. Thanks.
Judge, because he's bonded out, I can't see that information in the jail system. Not sure if it would be in the clerk's side or not.
Yeah, let me look. Let me see if I can find him. Looks like his current bond is 25,000. Now,
Is that on CR 2065, Judge?
CR 2065. It is.
Okay.
But I don't see that there's a condition of his pretrial release that he's on an ankle monitor. That's not checked. Let me show you what I've got here. Here's the ankle monitor.
Revision.
Ankle monitor. It's not checked.
Judge, let me go check with Miss Curry. We were under the impression that that ankle monitor was a condition of our pretrial release. We know he had one because he cut it off, but we were under the impression that was a condition of our pretrial release. It's possible he has charges in another county and they were their conditions. So I will follow up with Miss Curry and then get back to you if it pleases the court after we leave the Zoom hearing.
Okay, yeah, because that'll be important to me. So the court's policy would be to double this. However, if there's more aggravating circumstances, let me know, and then I will consider more than 50.
Okay, thank you, Judge.
All right, thank you, Ms. Heisel.
May I be excused?
Yes, ma'am, you may.